Getting a green card through marriage. 15 common myths. Hello, I'm immigration attorney Remzi Kulen. In today's video, we're going to deal with one of the most important topics we deal with immigration, getting a green card through marriage. And most importantly, I will walk you through the most widespread misconceptions and misunderstandings about this process one by one. If you or someone you know is planning to get married to a US citizen or a green card holder, please make sure to watch this video before doing so. Myth number 1, marrying a US citizen will automatically give you a green card. No. While getting married to a US citizen or a green card holder makes you eligible for a green card, it is not granted automatically. You need to complete multiple forms, submit documentation, and provide evidence. USCIS carefully reviews this file to determine whether your marriage is real, was entered into in good faith. Myth number 2, a fake marriage can get you a green card, no one will notice. This is extremely dangerous and illegal at the same time. If USCIS determines that your marriage is not real, your application will be denied, but not only that, you may be deported and you may be barred from applying for immigration benefits in the future. There are also criminal penalties, including fines and even jail time. Don't forget, USCIS officers are highly trained to detect fraud and pay attention to details in interviews. Myth number 3, you can apply for US citizenship immediately after getting married. Even if you marry a US citizen, you have to show that you have been living together with your US citizen spouse for at least 3 years before being able to file for naturalization. Not only that, if your green card is granted before the end of your 2 years in the marriage, your green card will be conditional. So you have to file to remove the conditions of the residency. That doesn't prevent you from applying for naturalization at the end of the 3-year green card period though. Most of the time, removal of the conditions and naturalization applications are adjudicated together. And don't forget, you must be married and living together with your US citizen spouse during these 3 years. Myth number 4, everyone's green card application takes about the same time. Not at all. The timeline varies depending on a lot of factors. How well your application is prepared, whether there are any missing documents, your local USCIS office's workload, whether you receive an RFE, request for evidence for the case. Now, receiving an RFE is not always a bad sign, especially if you filed the application a while back and USCIS is now asking for updated documents. That may be a good sign that they will waive the interview and just decide on the case by looking at those updated documents. So while filing the initial application and also while responding to an RFE, it is very important that you document your marriage properly. Some cases take 6 months, some cases take 12 months, you really don't know. Just because something happened to your friend does not mean that the same thing is going to happen to you. Myth number 5, a marriage certificate is the only thing you need. No, you must submit proof that your marriage is genuine. That includes submitting a deed or a lease agreement, a joint lease agreement with both of your names, joint bank statements, joint credit cards, photos together, travel history together, chat or call logs, letters or statements from family and friends. USCIS wants to understand that the marriage is not only legally valid, but it is also emotionally and socially real. Myth number 6, you can enter the US on a tourist visa, apply for a green card and get it, and there's no problem. This is a very sensitive topic. In some cases, it is possible to change your status from B2 status to a green card while you are in the US by filing a 485 application. It is your intention to come to the US with a tourist visa and get married and get the green card within the US. This is fraud. This could be considered visa fraud because you didn't use the tourist visa for its intended purposes. If you say, I'm here to marry with my fiancé and get a green card within the US while entering the US to a custom officer, you may be in big trouble. You may be deported and your tourist visa may be canceled. Always consult with an immigration attorney without making such plans. Myth number 7, you can get divorced immediately after getting the green card. Not so fast. When you first get the green card, it is usually a conditional green card valid for 2 years. If you get divorced during that time, your application will be scrutinized heavily. You still have to prove that the marriage was entered into good faith, but then the situation deteriorated. You are no longer living together or you are no longer a couple. One can easily understand this would not be so easy without the help of your spouse. However, this also doesn't mean that you should continue with your marriage if things are not working out just because you want the green card. That is also wrong. So you have to find a way to explain this whole situation to USCIS. These cases are reviewed more carefully by USCIS officers. You should definitely get an experienced immigration attorney to help you with these kinds of cases. Myth number 8, you can only apply for a green card while you are in the US. No. There are two ways to do this. The first application, which is the I-130 application, is always filed with USCIS. However, the second stage, if you are in the US, you can file an I-485 application, which is adjustment of status. If you are at the consulate, you will do your visa appointment at the consulate, and this is called consular processing. Myth number 9, every couple is required to attend a green card interview. Not always. If your application is very strong, if USCIS decides on your case very soon after you file the case and they don't have to see anything additional, then they may waive the interview and approve the case. But in most cases, USCIS will require the spouses to attend to the interview together, and this is by no means a bad thing. The interview is one of the most important steps of this whole application, and it helps the officer determine whether the marriage is real. If you're attending a green card interview at the consulate, the procedure is a little bit different. The US citizen or the green card holder spouse do not appear for the interview. The interview is only for the spouse who's trying to get the green card. Myth number 10, you need to apply for a K-1 fiancé visa before you file for a green card application as a spouse. This is wrong. K-1 fiancé visa is for spouses who would like to get married in the United States. If you have already been legally married in the US or in your own country, then you cannot file a K-1 application. If you're married, you have to file an I-130 immigrant visa petition for your spouse. Most people waste time and money because of this misunderstanding. Myth number 11, if your spouse is a US citizen, their income doesn't matter. It does. Every US citizen spouse, every green card holder spouse, if they're filing a green card application for their spouse, must file an affidavit of support, form I-864, with the USCIS or with the consulate. With this form, the US citizen or the green card holder spouse must disclose his or her income and also submit tax returns. Now, if your income is not sufficient, or if you don't have any tax returns because you didn't make any money, then you can always find a joint sponsor to back you up for these financial matters. So the first misunderstanding about this is US citizen spouse or green card holder's income doesn't matter. The second misunderstanding is if the income is not good, we cannot file a green card application. Well, actually you can, because you can use a joint sponsor. You still have to file your affidavit of support, but you can get a joint sponsor to back you up. Myth number 12, if the couple lives in different cities or states, then the application will be denied. No, long distance relationships are allowed, and it is very common in the modern world due to business, work-related reasons, going to school, or family or immigration-related problems. Long-distance marriages are allowed, especially for couples separated by jobs, school, or immigration restrictions. But don't forget, these cases are more closely examined by USCIS and consulates. You will need to provide extra proof of the relationship, such as flight tickets, video calls, visits, and messages. In this case, USCIS will expect more documentation from a long-distance relationship marriage case. Myth number 13, you can start working and traveling internationally as soon as you file the green card application. This is wrong. If you're filing the application within the US, while filing the 485, you can also file for an employment authorization document and a travel authorization document. These applications are usually issued together in a combo card, but they also can be issued separately. The rule of thumb is you shouldn't be traveling unless you get the travel authorization, and you shouldn't be working until you get the work authorization. Of course, there are exceptions to this rule. For example, if you are an H1 holder, or if you are an L1 holder, or if you have an OPT based on your F1, you can continue working under the terms and conditions of those visas. But if you want to change jobs without changing your visa status, then you have to wait for the employment authorization document that you filed with the green card application. With respect to travel, some visa categories allow international travel before receiving the advanced parole, such as H1 and L1. But almost all other visa categories, such as B2, F1, E1, E2, and you name it, you need to wait for your travel authorization in order to travel internationally. Myth number 14, green card interview is just a formality. They don't ask many questions. Absolutely not. The interviews are where USCIS officers try to determine if this marriage is real. Don't forget, USCIS doesn't have the resources to send you officers to see if you're a real couple at home. So what they have is this 30-minute to 60-minute interview where they ask you questions, assess your answers, observe your body language, and take a look at the documents. They may ask detailed questions such as, what's your spouse's birthday? Where did you go on your first trip together? When did you meet? How did things get serious? When did you start living together? What's your father-in-law's name? What's your mother-in-law's name? Did you meet them? If your answers don't match or seem rehearsed, your case could be denied. So you have to be very careful. I actually advise my couples to study the forms and the relationship history together, and I call this romantic homework. Don't forget, the USCIS officer will want you to appear prepared. So the argument that if a marriage is real, we're not supposed to remember everything is not true and does not hold in front of an immigration officer. They expect you to come to the interview prepared. You have to know your forms, you have to know your documents, and you have to know your relationship history. Myth number 15. Once you get the green card, you can stay out of the US as long as you want. This is wrong. Once you get the green card, you also have some responsibilities, and one of them is to stay in the US and try to become a US citizen. In other words, you're not supposed to abandon your residence in the United States, or otherwise you can forfeit your green card. Therefore, green card holders cannot live abroad permanently. If you have plans to live outside of the US for a long time, let's say more than 180 days, more than 1 year, for example, your school is going to take 2 years, you've been assigned to another work location in another part of the world for 2 years, definitely get a re-entry permit. Although I have completed 15 minutes, I'll throw in a bonus. Sometimes I hear that couples don't want to hire an immigration lawyer or don't want to go to an immigration interview with a lawyer because they think that their case may look weak. So in other words, if this is a real marriage and we're not faking anything, why do we need a lawyer? Only people who enter into fake marriages and don't have enough supporting documentation get lawyers to help them. This is entirely wrong. First of all, as lawyers, we don't take cases if we believe that they are fake marriages. We have to believe that it's a real marriages, and then we can represent you. The second thing is, officers usually like and use the help of immigration attorneys in these cases because they can communicate better, and once they talk and once they ask for something, the immigration lawyers what they need. That doesn't mean that immigration lawyer can speak on behalf of you during the interview. That is not possible. You will be responding to those questions. But if it's a legal issue, if it's a document that they cannot find, they can ask the lawyer to locate that. And also, the presence of an immigration attorney at a green card interview may prevent misapplications of law and regulations. Finally, an immigration officer may think that a lawyer didn't appear for the interview because maybe he or she discovered something about the marriage and didn't want to take part in the interview. So that's not a good look. I'm not saying that your case will not be approved if you are not represented by an immigration attorney, but it makes things much easier. It makes the preparation easier, it makes the application easier, it makes you understand the process better. It also makes it easier for the immigration office and immigration officer because we've done these cases many times before and we know what they're looking for. So today I try to explain you the 15 common myths in green card applications. I hope you liked the video. If you have any questions, please write them in the comment section below and I'll try to respond to them one by one. Also, please like the video and subscribe to our channel so that you will know what's coming next. I hope to see you in my next video. Take care.